Adjustment of status basically is for those people who are already in the US in a valid status. And it's exactly what it sounds like. You're adjusting your current status in the US to that of a green card. So this can be a really big advantage for people who are already in the US because it bypasses what can be a pretty big headache, especially at the consulate level. Different consulates in different countries, especially ones that experience high volume, such as China and India, often undergo really lengthy delays just to schedule an appointment. So that's probably the primary advantage is just bypassing some of the headache that comes with consular processing. One is you actually get status right away once USCIS receives and receipts your adjustment of status. So I hear a lot of investors say, oh, I'm going to get an EAD. At that point, I'm safe to stay in the country. It's actually much earlier than that. As soon as you get that receipt notice from the USCIS confirming that your adjustment of status has been received and accepted, you're now in what's called adjustment pending status. And so you're able to remain in the US physically, whatever happens next, right? So we'll take a kind of example here. Let's say you're in an H-1B role, you file the adjustment of status, and then 1 week after you receive the receipt notice for your adjustment of status, you get laid off, right? And 60 days pass, and you haven't found another job, no other H-1B employer, and you haven't gotten your EAD yet for whatever reason. Could you still stay in the US? And the answer is yes. Even though you can't work at that point, right? You don't have work authorization because the EAD hasn't arrived yet. But just physically remaining in the US, you absolutely can do just from the filing of the adjustment of status. Point three here then is the one that everyone kind of points to, and it is a huge advantage, right? While you're waiting for this green card, especially if you're in a backlogged country, and we'll talk about that a little bit later, then the EAD really does give you broad work authorization anywhere in the United States, right? So having that EAD is basically giving you the same work benefit that a green card would. A green card allows you to work for anyone, anywhere in the United States, including yourself. And an EAD card under this category, under the C9 category, which is for adjustment of status EADs, you have broad work authorization, able to live and work anywhere in the US. What also comes with that employment authorization document, often as a combo card, sometimes separate, is called an advanced parole. And this is essentially just advanced permission to leave the US and then return. It's a travel permit. So basically, let's take another example where you're, on H-1B, you decide to file the adjustment of status, but in the meantime, your H-1B visa has now expired. If you're Indian or Chinese, you know how hard it is sometimes to get an appointment overseas to get a new visa stamp done. Well, the advanced parole or the travel permit here will save you from that headache. You can now leave and re-enter the US without having to get re-stamped and worrying about all that. So the rule was actually updated just last year, and USCIS now issues 5-year EAD, and we've even seen advanced paroles coming in for that 5-year mark. And so the initial approval is for 5 years. For a lot of applicants, particularly those in rural areas, that's going to carry you to the green card issuance. But even let's say you're in a highly backlogged category like high unemployment, which we'll talk about, and you're from a backlogged country, you can actually extend that EAD and advanced parole for as many terms as you need to get the green card itself. So let's just say it gets crazy for some reason and it takes 12 years for you to get your green card under an EB-5 application, you actually could still maintain your EAD and advanced parole all 12 of those years. That would be 2 extensions, 5 years, and then a third 5 years, and then you obviously get the green card in the middle. So it really does, at this point, bridge whatever timeline you have from the day that you apply to the day that your family receives a green card. And it covers the entire family, right? The only limitation here would be if you have young children who are not legally allowed to work in the US because of their age, they wouldn't be receiving EADs. But pretty much the entire family, spouse, children, everyone included in the application, everyone that's part of the immediate family would get an EAD and an advanced parole. are. So the EB5 is just basically going with the 526E, right? This is the equivalent of an I-140, which is filed for an EB1, EB2, or EB3 application. The 526E is kind of unique to the EB5 experience, but it's the same equivalent. It's basically petitioning the government to provide approval for a green card to be issued. Now, in conjunction with that, what's called a concurrent filing, the government now allows for the 485 to be filed alongside the 526E. And the 485 is the adjustment of status. This application includes the medical exam that a lot of people will know about at this point because USCIS has now made it a requirement before filing the 485. Previously, it was a little bit optional. It will look at your immigration history. So if you've got 20 years of H-1B experience, you're going to have to show 20 years of approval notices and extensions and things like that. And basically, it will ask you a lot of questions about your admissibility to the U.S. if you've been arrested, if you've got any basically marks on your record that would lead you to be inadmissible. So that's what's being adjudicated in the 485. Now, when you file a 485, there are various different categories that it falls under. But when you're under an employment-based petition, like a 526E or the EB5 category, you get certain benefits. In this case, you're able to file for a 765, which is an employment authorization application, and a 131, which is a travel authorization. So all three of those, the 485, the 765, and the 131, all get filed kind of together. The 526E also gets filed at the same time. And think of it as two different packets. The 526E will go to the Immigrant Investor Program Office, or the IPO, and the 485 will go to whichever service center, depending on which state you live in, within USCIS. Working with an attorney that understands that you're likely going to culminate, within a 1 to 2 week period where everything should kind of line up, right? You should be making the project decision around the same time that your source of funds is basically ready to go and all the documentation has been collected, and you're going to be making the investment kind of as the very last step before you file the application. If you do it right, if you transfer your funds on a Monday, by that Wednesday, you should be ready to file the application. I think we still see a lot of attorneys that, maybe even tell investors to go ahead and wire their funds early, and then we'll work on the source of funds. Well, that can lead to a lot of problems, right? What if the source of funds isn't clean where they transferred from? So it can't be overstated just how important it is to work with an attorney who has a process in place. Every attorney is a little bit different in how they do it, but making sure that they're aware of the timeline that you're trying to meet, right? Let's say you've got a particular need to file by late February, you communicating that to the attorney, and they're giving you set timelines for when certain steps should be completed so that you can get that filing out the door and make sure that you meet whatever deadline it is that you've imposed for yourself. Yeah, absolutely. So, we talked about some of the advantages of an EAD and advanced parole versus a green card, and you'll see here that it really is very similar in terms of the benefits that you're getting, right? The peace of mind of a green card is its own, but other than that, the authorization that you're receiving is very, very similar. I think the main key for an EAD is that you do have the ability to work anywhere in the US, and it's broad work authorization. What do I mean by that? It means you can have 2 jobs, you can have 3 jobs, you can have no job, you can work for yourself, you can start your own business while working for somebody else. There's any number of kind of combinations that people can get into that are actually going to be 100% okay with an EAD in hand. It gives you broad work authorization with almost no restrictions in terms of what you can do. And so, yeah, if you wanted to work, a day job and drive an Uber at night, you're free to do so. If you wanted to work on your startup while also working at a big tech company, you are free to do so. Now, CBP has been known to give people traveling on an advanced parole a slightly more difficult time than if you just have like a green card, for example. You may have secondary processing, but there's no legal reason to turn you away at the border. And I've never heard of anyone being turned away just because they are traveling on an advanced parole. So it really does give you the freedom to travel anywhere in the world, right, that you have a visa for or travel authorization for, and ultimately return to the US without having to worry about getting a visa stamp for whatever other category that you're currently in the US for. Yeah, as Sam has mentioned, it's super important to work with an experienced attorney who's dealt with these situations before, and so therefore knows how to handle each situation, who to contact, which department to push, what emails to send. We used to work with investors all the time who they entered through CBP, and they just entered willy-nilly, didn't really care about anything, but their I-94 was actually updated incorrectly in the system. They'd entered maybe as an H-1B investor, or sorry, H-1B visa holder, but the officer put them in as an F1, and that would technically mean that you're working without authorization because your I-94 is incorrect. Well, someone who's not experienced with this might freak out and not know what to do. But we worked at Fragment at the time. I was working at Fragment at the time, and that's a really big shop with a high volume of cases. So you see a lot of situations like that. We knew exactly who to contact at CBP to get that updated and get that fixed so that the foreign national didn't accrue any basically work without authorization or anything like that. So yeah, it's super important to work with an experienced immigration attorney. USCIS, like any government organization, is not perfect. They're going to make mistakes. Mistakes are okay, right? It's if your attorney's on your side and zealously advocating on your behalf and making sure that those mistakes are fixed. A mistake that goes unchecked is what really becomes a problem down the road. But at the end of the day, we are really only responsible as a regional center for the project side of the equation. We're the ones who are basically making sure that the development and the developer are doing everything to meet the immigration standards that are set forth by USCIS for any project that you're investing into. And that is job creation, that is expenditure of capital in accordance with the business plan. That is making sure that we're tracking everything so that when it comes to 829 filing time, everything is ready. We've got that initial kind of job of getting the 956F filed and approved by USCIS. And I know at EB-5AN, we've been incredibly good about that and getting those approvals very quickly. But then also there's the second step, which is the 829. And I think this is where a large regional center operator that's been doing this for a long time really separates themselves from a small operator who's starting off on their first, second, third project. A regional center that's been around is going to know the amount of work that it takes over the course of 4, 5, 6, 7, sometimes even longer years to get the 829 done correctly for investors, right? Backlogs can really extend the timeline that regional centers are under the gun, so to speak, with an 829. Newer operators, often they're more business minded. They're getting into the EB5 space for business purposes, less so immigration purposes. And they're not going to focus as much on how much depth you have to go into on the tracking and everything else that goes into the 829. I mean, we're literally seeing how every dollar is spent, that is spent in accordance with the business plan on EB5 eligible costs, and therefore creating jobs required for EB5 purposes. And that's not an easy task, especially when you're not focused on it as your primary kind of goal. So, or your primary job. So regional centers, big experienced regional centers that have done this for many years, that's super important. I think you can see the approved rate is really, drastically improved. And that's the other number that I think has caused for a lot of people to have confidence in EB5 again. So seeing those people file in early 2023, receive their approvals. I know that we're, I think we're over 200 approvals at this point from since the RIA, the Reform and Integrity Act, really provided a clear pathway to filing an EB5 application and getting that green card. And then the early kind of adopters of that and filers within the program now receiving their green cards and sometimes as early 2024 and sharing their stories. We've got a bunch of testimonials on our website of people getting their approvals in a timely manner. That's what led people to say, hey, this is something that I can really get behind and go forward. And that drove a lot of demand. We also saw a big spike in 2024 of approvals. And I think, this is not just approvals of people filing post-RIA, but even people who filed pre-RIA. This was USCIS's first year in a long time where they've really put an emphasis on getting people approved and issuing those visas abroad. And that's really encouraging for new investors. Not only does this mean that in the short term, we're starting to see people actually move through this program and obtain their green cards very quickly, but it means that we're starting to clear out some of those backlogs that have been really plaguing this program for a long time, particularly for Chinese nationals. And the quicker that USCIS processes these applications, the less visa waste there is that carries over to other categories. And the more we see people as success stories. And success stories, I think, are really what always drive any program, especially with investment, right? When this much money is involved. And you can see here that when we look at kind of the trend, everything is trending upwards in the right direction for EB5. Sure, we're seeing a lot of applications and receipts being filed, but we're also seeing a lot of processing. And significantly in 2024, we saw a lot more petitions processed than were filed, which is great. Seeing processing outpacing demand is what we want to see with any government program. Well, now USCIS has really cut down on the time for 956F approvals. I know we've gotten some approvals in as little as 2 months. And so I think this chart really signifies the importance of going into projects that have 956F approval. You go into those projects and USCIS is now no longer kind of tasked with looking at the project and waiting on that project to be approved before looking at your source and path of funds. They can just go dig straight into your source and path of funds. And Sam, I know we've both seen clusters of approvals within projects that have that 956F approval. So the likelihood of you gaining that approval and getting your green card much faster definitely increases. And the timeline for that decreases if you're going into projects with 956F already approved. What really you need to ask yourself is, do I want to file an adjustment of status? And if you want to file that adjustment of status, you have to do it before the bulletin backlogs. And we know it's coming. It might be coming for both categories. It's very clearly coming for high unemployment. For rural, it might only be a few months or it may not happen at all. Just kind of depends on how the Department of State sees those numbers playing out. But if that category changes from C on the visa bulletin, which stands for current, to a date, if you're filing after that date, you're not going to be able to file an adjustment of status. So that's really the big worry for a lot of investors is, am I going to get those immediate benefits? Am I going to be able to file my adjustment of status? And you probably only have a few months to do that if you're in that boat. Historically, we've gotten that warning, and within about 3 months, we've seen the backlog actually hit the calendar, or hit the bulletin. In India's case, in 2019, it actually hit even sooner, just 1 month later. I don't think it's going to be next month. We would have gotten a little bit more specific warning, but I think 3 months is a pretty good estimate to expect a backlog to either hit or be very close to hitting. And remember, when that is the case, a lot of people are filing their case. A lot of people are going to be filing their application and getting in. And if you're an investor who's thinking about EB5, there's no time like the present, right? You don't want to end up in that last little bubble of bunch of filings. We saw that in November 2019 before the program lapsed. Everyone kind of knew the program was going to sunset. They weren't sure how it was going to come back, or if the amount was going to be higher, or what was going to happen. And we saw an incredibly high amount of filings in November 2019, and it took USCIS up until now basically to adjudicate all those. So you really want to beat that rush if you can. If you're watching this webinar, chances are you're considering EB5, you should probably go ahead and talk about it with your family and pull the trigger sooner rather than later. When is going to be your deadline to really get in and make sure you can still adjust status? It could very well be as early as March. We're maybe just a few months away from that being the case. When will you know when you have to file by? You're only going to get about 20 to 25 days of notice. The visa bulletin for the following month is published in the current month. So right now, if it's January, let's say 10th, you will just find out what the February bulletin looks like. Until January 31st, you are now able to file your application as is. The status quo is maintained until February starts, and then February's visa bulletin will dictate. So once a cutoff appears on the visa bulletin for the next month, you have until the end of the immediate month to get your application in. If, for example, let's say in February we find out that March is backlogged, the March bulletin is no longer current, you'll have until the end of February, which is already a short month, to get your application in and file concurrently to get that adjustment of status. And so what I'm really trying to get at is you got to start now, right? You got to start as soon as possible, because the last thing you want to do is get stuck with maximum 3 weeks remaining and have to go through a subscription process, an investment process, moving your funds, collecting your funds, sourcing your funds, getting everything ready, understanding all the tax liabilities of moving money from overseas or into this investment, understanding all the immigration ramifications, the restrictions on travel, the restrictions on work, all the different strategies that you have to kind of undergo when you're doing an adjustment of status. All that has to be done in 3 weeks. So it's, I would venture to say that if you've not got an immigration attorney hired already, looking at your documents by the time a visa bulletin drops with an impending deadline, there's a really good chance that either a mistake is going to be made because you're rushing through, or an attorney may not even be able to file your case because you just haven't started early enough.
I think two main points just to kind of summarize here are, for those investors who are more concerned or more focused on getting their capital back faster, the urban projects are going to be the way to go. If you're more focused on getting the green card, for whatever that underlying reason may be, getting the green card faster, rural is going to be the way to go, right? And kind of the reverse, will be true, right? If you're in an urban project, you're going to be getting your money back faster, most likely, but you're going to be waiting longer for the green card because it's not priority processing like rural, and vice versa. Rural green cards coming faster, but the investment period is going to be a little bit longer, right? So you just kind of decide, given your investment situation, your financial picture, family members, immigration goals, benefit of the green card versus the work and travel permit, what is more important to you, getting the green card faster or getting the money back, with a targeted investment return faster, and then kind of apply that framework and then select, the most compelling urban or rural project that makes sense given your unique situation. The second thing I want to mention is that regardless of what project you end up selecting, before you can even really focus on project selection, you've really got to hire the immigration attorney, go through that source of funds process. That can take, as quick as 2 weeks, but it can often take, 6, 7, 8 weeks, depending on how many documents are going to be needed. Are translations going to be required? How easy is it going to be to track down, that birth certificate from a foreign country? If money is coming as gifts from friends or relatives, you're going to have to work with those family members or friends to provide all the documents, bank statements, tax returns, showing how they accumulated the funds legally before they've gifted them to you. So there can be a lot of documents needed, and you can't really finalize your project selection and invest money until that first step is completely done, right? So once you decide you want to do EB-5, first step, interview a few immigration attorneys. Ahmed and I, have worked with many attorneys over the years, and all attorneys are not equal. Some are better than others, and also some are going to be better than others given your unique situation, right? If we have a client,
Right.
From Canada versus a client, from Spain or from China, the best attorney for the investor from China is not going to be the attorney, that's going to be best suited for the Canadian investor, right? So you want to make sure that you're speaking with a few attorneys that have experience working on similar source of funds packages, to what yours is going to look like.